We want to see a world in which slavery doesn't thrive, and for that to happen, we need to see we still need to see quite a lot of change.
We've got very much more serious sentences for people who are convicted, life sentences if they're found to have trafficked, which is much more stringent than it used to be.
One of the things that's been really successful is the fact that it's given the whole topic a lot more visibility. And like I said, that's a really cool part of the solution, because without visibility, you can make the legislative change you like, but unless people recognise, what the problem is around it, it's not going to change anything.
At the Business and Human Rights Resource Centre, they have done quite an expansive study on the impact of the UK modern slavery law, and have found that even on the limited scope of reporting on one specific set of rights, there has been very inadequate reporting, and it hasn't produced the kind of results that the theory of change would suggest.
There's still a heck of a lot of problems around the UK's provision of support and services to victims, and also its approach. I mean, it still has a pretty heavy immigration-oriented approach to tackling trafficking, which is very unhelpful.
The Australian federal law that was passed applies to businesses that have a turnover of more than $100 million a year. So effectively around 2,500 companies are affected. What's interesting is it also sits alongside a state level piece of legislation. So Australia has 6 states and 2 territories, and one of those in New South Wales has passed a state level law, which in fact actually has a lower threshold of $50 million, and also establishes an anti-slavery commission. The Act in Australia also has extraterritorial reach. So it means that the Australian law applies to Australian companies operating abroad, who then need to disclose risks of exploitation in their supply chains domestically and overseas.
The Modern Slavery Act in Australia also contains provisions on business. We wanted to see much clearer penalties put in place, and if there are financial penalties, we know it works.
If we want to look at a legislative response, there are 3 mechanisms, some of which exist in the Modern Slavery Act, and the first one is the nature of due diligence, and this is where the Modern Slavery Act is quite weak. Due diligence is not merely about reporting, but it's about action.
If it became law, the first and foremost goal would be to compel companies of a certain size, which in this case is, I think it's $20 million worth of sales and $40 million worth of assets, to compel those kinds of companies to disclose on an annual basis to the Minister of Public Safety that they've examined their supply chains and that they are satisfied goods produced from slavery is an unacceptable moral purchase or moral issue. Education would be possibly the most useful initiative that a government can undertake.
The perspective of our network is that a focus on transparency alone, on reporting alone, or on respecting a single set of rights alone is not enough. Articulate that companies have a responsibility to respect internationally recognized human rights, that it should require companies to take measures to identify, prevent, mitigate, and account for how to address human rights and environmental impacts. This law should articulate that companies' responsibility to undertake due diligence flows throughout its entire supply chain.